Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago as usual. And I've got Alex from our Nevada Judges. Say hi, Alex.
Hey.
All right. We've got some more Hillygus and Handte here. I was going through the playlist. I think I've surrendered on that. Not really. Just I think I covered what I needed to in this case. If y'all recall, I got into it because Hillygus was going full soft sit at a hearing. That's a more recent hearing. Today we're going to do, I think, the most recent hearing. Isn't that right, Alex?
Yeah, that's the most recent one.
I actually don't have the date, but I'm talking like 5 days ago or something like that.
Right, yeah.
Okay, and it's going to catch us up on what is going on. This confuses a lot of people. I get it in the comments, because, for instance, Hillygus is represented, then he's not represented during this. So currently, Hillygus is not represented. Isn't that right?
Correct. That's right. His last attorney was Steve Evenson.
And he's on the lam. They issued a bench warrant for him.
Right. Still pending.
For what? Failure to appear?
Failure to appear. Yeah, he still has not been apprehended. There have been rumors a few times about him being apprehended, but I never believed him, and so I never posted anything on him. So,
right. So, and the judge in this case, he's affirming at this hearing, we don't have him.
Yeah, he's affirming that they don't have him, that the court doesn't know anything about what's going on with the status of that. I did notice that Deputy District Attorney Amos Steggy did mention that he did have some insight. That's in the video, but he doesn't go into what the insight is. I just assume he has more contact with the police that are after him than Judge Breslow does, which is pretty normal. Just Breslow, any judge is going to be busy.
Okay. Well, let's get the party started. But just for anyone who's confused, I'll do a quick recap of this. Hillygus and Handte are co-defendants in a case where Mr. Hillygus was charged with kidnapping his mother, and I guess Handte is charged with that as well, or being an accomplice to it, or some such thing.
Something along that, yeah.
Mr. Handte is a former law enforcement officer. Again, I think a former state trooper and a former sheriff.
Right. I have some more detail on that. I understand that he worked as an officer at a reservation. I haven't memorized which one it was. And I also do understand that he was a state trooper. And yes, he was appointed to the sheriff, to be the sheriff of Mineral County. And I believe he lost the election. And that's it. I mean, these details will probably be online, but my understanding is he was appointed to the position, an election came, he lost the election, and that was the end of that.
Okay. So for those of you who have been following along, I've been going back through Alex's playlist, which is awesome. And by the way, I always edit and cut a lot out to make it shorter. If you want to see all of it in its completeness and without me, trampling all over it, go to our Nevada Judges. You've got a Hillygus and Handte playlist, right?
Correct.
Well, yeah. What am I doing? Yeah, I'm using the playlist. What I was thinking of was Blandino. Thanks again for that too. The Blandino stuff was so fun. That, by the way, that's coming up in July too for sentencing.
Right. We'll broadcast that live.
All right. Well, now you know. All right. Let's get this party started here. No. There we go.
Okay. Why are we having this hearing? Well, I said a status hearing. I said it, before, passed in the night, the motion by the defense to reconsider the court's prior decision on bail. But we'll get to that in a minute. But let's talk about the lay of the land. First, we are currently set for next Thursday, April 7, starting at 9 o'clock in the morning, a final pretrial conference and motion hearing on any pending but not yet decided motions. So we'll talk about whether that's still going to happen, and if so, in person or remotely. Number one. Number two, this trial is set on the stack that begins May 2nd. You're currently set for a 10-day trial, Monday, May 2nd. I want to talk about the viability of that date for a couple different reasons. preview of that issue is, number one, I have a sexual assault trial set at the same time, also with somebody in custody. Number two, neither trial is going to happen then because that week, May 2nd through 6th, is the every 4-year statewide judicial summit. To borrow a phrase from Hunger Games, it's the quarter quell. This is a big deal. All the judges, limited jurisdiction, general jurisdiction,
Hunger Games reference
throughout the state meet for education, training. Keynote speaker, Anthony Kennedy. My attendance at that, although not formally required, has been strongly encouraged. Next, we still have Mr. Hillygus on pending warrant status. I haven't received any word that the warrant has been served.
Pending warrant status is fancy talk for he's on the loose.
Yeah.
So I assume it is not. Then we also have a recently filed motion to reconsider the bail, as I mentioned, and other logistics issues. So that's why I set this hearing, right? That's why I set this hearing. I want to know if the state still intends to go. Does it intend to go as against Mr. Handte only? Does the state understand that there's virtually no chance of going May 2nd because of the judicial summit, or the following week because of the other matter that is taking priority, state of Nevada versus Manuel Perez Sanchez? Just so you've heard the case number, if anyone wants to look it up.
All right. Alex and I spoke about this briefly beforehand. The judge is cracking me up here because this trial is not going May 2nd. I don't know why he just doesn't come out and say, this isn't happening May 2nd. The other trial doesn't matter. He's going to that judicial conference. He wants to. That's fine. Unless they have some speedy trial deadline, that's what's going on. But the second thing is fascinating. This is for you true law nerds out there. They start flirting with the notion of severance, namely severing these cases and trying them individually. It's a horrible idea. It's all the same facts and witnesses. It's a horrible use of resources. And actually nobody wants to do it, which actually makes sense. But that idea is not going anywhere. I don't know why the judge keeps playing with the other case, or he says, well, you know, what does the state think about going on this date that I'm telling you is not available? It's fascinating to watch.
He's different. He's different than a lot of the other judges, that's for sure. I mean, I don't think I've seen a judge go into all those extras before. Maybe Judge Timothy Williams a little bit, but not to the extent of, Judge Breslow. So he does have a different approach.
I was wondering if he was getting pushback, but you'll see that Steggy doesn't care. Plus they really can't go, and they'll tell you the reasons why.
Yeah.
CR 20-3521. And then the court does have the 2 weeks after that available as well. Okay. Let me start with Mr. Steggy, then Mr. Pitaro. I'll ask you some questions and to weigh in. What do you think about the status of the trial in light of Mr. Hillygus pending warrant status, Mr. Steggy?
I think it is not viable given the current lay of the land. I will say, familiar with the status of the warrant and at least some of the efforts to secure Mr. Hillygus. I think even assuming he were to come into custody in short order, it might be difficult to go to trial on this next stack.
Okay, so the next stack just means the next stack of cases that's going to proceed to trial. And we talked about this briefly. Mr. Steggy right there, you said, I'm familiar with some of the efforts. I'm interested. It doesn't really matter. We're reading tea leaves right now. Who knows? But I read that as Steggy thinks we know where Hillygus is, and we'll pick him up when we need to.
I don't know. I mean, I don't think I'd be surprised. I just have never been one to think that it's that easy to hide. You know, in the modern society, everything's interconnected, wired. I don't know. I don't know how he's been able to hide this long, but I mean, I guess I'm a little bit ignorant as to how any of that works.
Well, you can't have a phone.
Right. There's a lot of things that I imagine.
You can't have a phone, and you can't use an ATM.
There was I wish I could remember the quote verbatim, but Natalie from Natalie Lorachik talked about it. She said all of her clients who ran, they were always caught. And I just never forgot that when she said that, how it's just not a thing anymore that you can just run off.
Yeah. I mean, I think the only way, and I think they still get you quite easily, but I think the only way you can even begin is you can't do anything modern.
Right.
You have to go full mountain man.
Yeah, exactly. That's tough. I mean, I couldn't do it.
Yeah.
Though I think it could be done.
Well, he still has to submit to competency evaluations and then a hearing, and then depending on the evaluator's position, everyone gets to be heard, maybe an evidentiary hearing. I mean, it's near impossible, even if the warrant were served as we speak.
A big lift, to sort of borrow a current phrase, for that to happen. Flowing from there, I think, are a few sort of issues. If the court,
They haven't done a competency hearing on Hillygus?
I don't think so. No, they didn't. And the only reason he wants to now is because of that one video where he started to say he appeared by divine special appearance and all that stuff.
Well, I mean, you know, that's fair.
Yeah, I mean, that's the only time that he ever felt it needed to be done. And
you're right, and that's fairly recent. I mean, that was this year. I don't know, was that February or March or something? No, that was January, February, probably.
Yeah, I think it was 2 hearings ago, maybe 3 hearings ago.
All right, the other one I want to bounce off you. The last hearing, in that hearing, he showed up in a wheelchair. Handte.
Yeah, and now
he's got a walker.
Right. I don't know.
Was there any discussion or anything out there? Is any reason why for this change of setup?
No, I mean, it's just even more rumors. I get a lot of emails from the Roger and Stu supporters. I can't do anything with them. It's not in our publication format, but they do talk a lot about the wheelchair. Supposedly something occurred in the jail. I mean, it's just, I don't know what to do about any of that stuff. It's just emails that I get that I don't publish. We don't publish that stuff.
Yeah.
They send it to me because they're upset and they want our Nevada judges to intervene and take a side, which is just not something we've ever done in the case. All I have is just more rumors and suspicions from his supporters as to
that you can't verify and therefore can't pass along.
Right. So don't know. I don't know why. I don't know what happened or what's going on with it.
Wants me to address those, or I'm happy to continue in the question.
Well, go ahead. And then, with respect to whether the state would be inclined to seek to sever or not oppose a request to sever by Mr. Pitaro if he decided, he and Mr. Handte decided strategically it was in their best interest to move forward by themselves. And then I'm not sure what the state's position would be, but and then the fact is that we really can't go until the 16th at the earliest in this case. So with all that, Mr. Steggy, what else would you like to say? Hold on, Mr. Pitaro.
And I think what Mr. Pitaro is going to say is that he and I have discussed this eventuality, this question of whether Mr. Handte ought to go to trial on his own. Now, putting aside the issue of whether I would agree to severance, I will say, and I will say I am against severance, but my understanding is the defense's position is that they ought not to be severed, that Mr. Handte is desirous of going to trial at the same time as Mr. Hillygus. So I think that should be the proper outcome. However, if I do not want that agreement, or if that is the result, I don't want that to influence the court's decision on the bail issue. The idea being Mr. Hillygus's wrongdoing, sort of willful wrongdoing against the court and against this process ought not to benefit his co-defendant. And if necessary, I can provide additional information on that. Well, and I think I did. I'll reference my bail motion where you have Mr. Handte encouraging that Mr. Handte be unavailable for the competency proceedings, so sort of Handte's own actions not to contribute to severance and more appropriately to the court's decision on bail, the reconsideration issue.
Mr. Pitaro.
Yes, Your Honor. The reason I was trying to interrupt was exactly for what Mr. Stagey said. At the last court hearing, I had told the court that I would be prepared to go to trial with or without Mr. Hillygus. I then had a conversation with Mr. Handte after that, and he told me that he wanted to go to trial. He did not want to go to trial alone. He wanted to go to trial with Mr. Hillygus. And so what I did is I called Mr. Stagey and informed him that Mr. Handte's position, my position had changed, and that we did not seek a severance. And so that's what happened. I told the court I would want to go to trial, and then Mr. Handte told me he did not want to under those circumstances, and I informed Mr. Stagey of that fact. So given that, I assume, and given what the court says, we're not going to be going to trial on those times. Now, believe it or not, I've just had a complication as far as May, and that is that there was a trial that was set. It got continued. I told the state judge down here that I was having a conference call in an hour, which is now. I just got off the Zoom meeting on that one. And
oh my God, I've cut most of Pitaro out of here for this reason. He makes sense the whole time, but I'll translate all of that. No, we don't want to sever. He could have said that. He could have said that, and then we could all move down with our lives.
the judge under no that I would anticipate if the court was going to continue this matter based upon the severance issue, but we would be done by the 15th, and therefore, if that judge wanted to set the trial after the 15th,
thank you. It's
then
just
I
Judy.
would definitely, as I told the court, give my promise that they had to wheel me in a wheelchair. I would be there, but that was after the 15th, and of course, now the 2nd and the next week down up here is gone. So I'm sort of in a pickle based upon my misinterpretation or malinterpretation of what I thought was going to happen. So if the matter does get continued, then I'm going to unfortunately need it sometime in maybe into June. So that's the problem I have there. I don't know if you want me to address the issue of bail was not one of a significant change in terms of bail status or what the court had set as bail. It's the
Hold on. We'll talk bail in a minute,
okay.
or we'll agree to talk it next week when we were supposed to have our final pretrial conference. I know Mr. Handte and the defense would like to talk about it right now. So, I get that, but just let me process this for a minute. The week of May 2nd is out, even if the matters were severed. The week of the 9th is out because you're trumped by a Cat A case. The week of the 16th, you've given, it sounds like a soft promise to the judge in Las Vegas about your availability. And then we have Mr. Hillygus on pending warrant status, of which, by the way, I know nothing. I mean, I know less than nothing about efforts to serve, success or failure to serve, avoidance or not. I know nothing about Mr. Hillygus' actions other than I have not learned he's in custody. All right. But we all understand that if and when he's apprehended and he's in custody at the Washoe County Jail, he's subject to evaluation of two professionals. And although, I can pull strings, not on their professional work, evaluation techniques or conclusions, but on trying to get them in to see him as quickly as their schedule allows, we're several weeks away from having a hearing on what the results of those are. So it seems to me that we should, by the time we're done with this hearing, vacate the current trial date, vacate the motion to confirm, have the court direct you two, counsel, to reset it with Kylie Lane, the jury commissioner, as your schedules allow, taking into account the realities that we're facing, not to set it in a year, not to set it in 9 months, not to set it in 6 months, but get it set in the reasonably near future. Let's be optimistic that we can have Mr. Hillygus evaluated sooner rather than later. And once we have our new trial stack and motion to confirm date, we can set a closer in time, more realistic final pretrial conference. That would be my thinking on that, regardless, frankly, Mr. Pitaro, if Mr. Handte remains in custody or not. But before I order that, what do you think about, Mr. Pitaro, what I just said, please?
I have no problem with that. I had my calendar pulled through September, and
All right, we're ready to go back on the record, Judge, when you're ready.
Oh Lord, let me give you the Chicago version of everything that just happened. If a judge in Chicago rolls out and says May 2nd's not happening, we don't have the second defendant in custody. When we do get him in custody, we have to have him evaluated. So everyone look at their calendars for July and August. That's it. Next. Then we'll revisit bail. That's what's going to happen. I'm telling you, with 9 out of 10 judges in the city of Chicago, what they arrive at the same place. They just do a lot of talking to get there. All right. So they actually break. I thought that was interesting. If you're following this case and you want to know what's going on, it looks like a July trial date currently. They're not severing, so they're going to be tried together. Hillygus is still on the loose. They don't have him. What I read into Steggy's remarks is we don't have him, but we can grab him when we feel like it. That could be wrong. That's my gut feeling based on what he said.
Yeah. I mean, I didn't read it. I didn't remember it that way, but I trust you more on it than me. I mean, this is the first case where we've had this is the second case now where we've had a defendant take off.
Yeah. I mean, my tea leaves could be off, but that's my gut reaction. I'm not saying it's truth, but that's it. So they come back and have the real fight. Don't worry, I cut most of it. I just cut all their arguments out. I gave them basically their main argument, each of them like a 5-second snippet, because they each go for 20 minutes when they needed to go 1. And the judge does as well. It's kind of interesting. I'll overview it. The prosecutor says, "Hey, we've had 2 bail hearings, and there are no circumstances have changed, and this guy is completely unreliable. Bail should not improve." The defense attorney says, "This guy can't make bail. Nobody trusts him, and his name's been slandered by this case, which happens in every case, by the way. You're a criminal defendant." So there's no way he can make bail, and there's a case in Nevada that says basically you just have to let people out if at all possible. I'm oversimplifying, but that's the short of it. And I just cut out 40 minutes of them talking. You're welcome.
Thank you.
Thank you, Deputy. All right, Mr. Pitaro, did you have enough time to speak to Mr. Handte?
Yes, I did. Thank you, Your Honor.
All right. Anything else to add or comment upon based on the discussion you, Mr. Steggy, and I had with respect to vacating the trial and resetting it, promptly, along with the associated pre-trial deadline, so we can move this matter along?
Your Honor, I spoke with Mr. Handte about it. We're going to get with Mr. Steggy. We'll see what we can do early July, see if we can work that out with him in the court. The other thing is, and I don't think we need that hearing the next week. I think that can be rescheduled also, Your Honor.
All right, thank you. Mr. Steggy, your thoughts?
No additional thoughts. Thank you.
All right. It's the order, and we're not done. We're going to talk about bail here in a minute, whether a decision will be made or whether I'll let the state take a position in writing, but we'll talk about that in a minute. But first things first, Trial is vacated. Motion to confirm hearing is vacated. Pre-trial hearing next week is vacated. Parties are directed to promptly contact court's jury commissioner, reset the case for trial on an upcoming stack.
No, I have
Let's
not.
do our level best to have the trial set within 3 months and the associated pre-trial deadlines. The week after the July 4th holiday week, I already have a trial starting, a category A.
Knowing too well.
I know that because we had a pre-trial hearing on it this morning. That's one, Mr. Steggy, that, as I recall, the public defender, pardon me?
Mr.
Nailed it.
Hoppy was there this morning, Your Honor.
Yeah, that's right. You were there also with Mr. Hoppy and Mr. Arascata, right? So you know what that case is about. Category A, murder charge. But I am of a like mind. Summer trials don't scare me like they seem to scare other people, and I'm ready, willing, and
That just strikes me as odd. He's saying summer trials don't scare me. Is it just because it's just so freaking hot in Nevada in the summer?
I've never heard of this before, especially not in Reno. Reno is not as hot anywhere near as bad as Vegas. So I'm not sure what that's about. There must be something that I don't understand. Something among.
I mean, I don't like setting trials in January in Chicago for a lot of reasons, but prime among them is it's just nasty.
Mm-hmm.
And then I've got a cranky jury and the burden of proof, and no thank you.
able to preside over this matter as soon as we can get it scheduled. All right. Now, as to the bail, right? As to bail. So we have a motion for reasonable bail. Really, it's a motion asking the court to reconsider. So the question is, do we take the opportunity right now for the court to hear from both sides? Or does the state, insist on their right to respond in writing and then have the court either decide it or set another hearing? Let me tell you what I'd rather do. I'd rather decide it right now. I know Mr. Handte and Mr. Bitar would like it decided now, but I didn't want to confuse people by the fact that I had set a status hearing today. That was just a coincidence that it
I actually kind of like the judge's approach on this particular thing. He's saying, can we just address this bail issue right now? Because Steggy can certainly insist that, no, I have time to respond in writing. The judge knows it. But he says, I would prefer to do it right now, but I'm not ordering it because I can't. So that gives it over to Steggy, who handles it. But it's very gentlemanly.
got filed at the same time, roughly, that the request to reconsider the bail order was. So with that being said, Mr. Steggy, are you prepared to argue it now, or would you like me to set a hearing on it promptly?
Judge, I have a draft of my bail, my opposition. If I can locate that, that would be helpful.
And make argument from it?
And make argument from it. I have a strong position against that. I think the court will probably.
Well, so procedurally though, if assuming you can put your fingers on that and you recall your thoughts that you were going to express in writing, do you have any objection for me entertaining that motion right now?
In this instance only, I don't oppose it. So procedurally, I'm okay going forward today, but I want it to be quickly forgotten by the court should I argue a different position in another case.
Okay, fair enough. Mr. Pitaro, we'll start with you. The court will entertain it now. So I've got the motion, and go ahead, Mr. Pitaro, when you're ready, turn your microphone back on, please. Mr. Pitaro, I have a motion which essentially says, Judge, please walk back your prior order a little bit because the amounts that you indicated for the bond are beyond my client's reach. And so he's been able to, as I understand it, save up or have access to the $7,500, but not the security. And the defense argues that justice will not be disserved if the court were to modify its prior order. The court has Mr. Handte's attention. He would
Agreed.
be placed with a electronic monitoring device, location only, before he leaves the jail. He's certified already. He has no firearms under oath. He'll abide the court's order on staying away from people he has no business associating with. He won't associate with Mr. Hillygus while he's on pending warrant status. And so the defense says,
That's actually interesting. When they say don't associate with Mr. Hillygus, I get it. Those are the partners in crime that caused the whole mess. However, they're co-defendants in a case, and if you're defending, you absolutely would associate for the purpose of preparing your defense. I just find that interesting.
Mm-hmm. Maybe
But
it's
he's saying no.
He's saying only while he's on the lam. I think he specifically limited it to just while he's pending warrant status.
Yeah, he really does. He really does. Now that you mention it.
please review and edit downward your prior order to be 7,500 cash only and dispense with the security position. Is that right, Mr. Pitaro?
It's a very good argument, Your Honor. You should be a defense attorney.
Well, here's the problem I have, and I know. Let me tell you that some of the concerns. Number one, remember how we got here, right? Mr. Handte was out of custody, and it was the state of Nevada that asked me, among other things, to completely revoke his bail. The court declined to do that. The court said, no, I do not find good cause. And all the court did was order recertify, no firearms, stay away from people that you do not have any business being around. That's in the vernacular, and put on the GPS tracking. Your client, as we all know, disregarded that piece of the order. I understand you and he expressed the reasons why the GPS was of concern. But then, as the state pointed out at the last hearing, he went to Elko with Mr. Hillygus, or it was at least pulled over in that county. They had thoughts of going to Eureka. They had already gone to California. And so the concern was that, and I expressed concern that Mr. Handte might be headed toward the East Coast, where his estranged wife and her family were, but he disavowed any intention to do that, which I accepted. All right. So then, over the state's objection, I did revise the bail order, the 100,000 lower. Indeed, you might not feel this way, and certainly Mr. Handte does not, but I thought I was doing Mr. Handte a solid here. I cut the amount in half, and I made it bondable. In the world of fair and just bail decisions by the court, I thought that was giving Mr. Handte the benefit of the doubt on many of the issues that the state has asked the court very strongly not to give him the benefit of. Now, when counsel says, but judge, that's beyond him, right? The financial status of somebody for whom bail is being sought is a factor. We all know that under the U.S. Constitution, you have a right to reasonable bail, but not necessarily right to bail that you can make. That's number one. Number two, we have a 30-year veteran, peace officer veteran, who proudly served in many capacities in many locations. That's not lost on the court. But what's also not lost on the court, Mr. Pitaro, is that of all the people that he's interacted with personally or professionally, it's a little bit telling that there's not a single person willing to post something of value of $50,000. In other words, are they worried as well that he might not appear for court and they would lose their collateral? Do they know him better than the rest of us? Does he not have family or friend support to that level? I mean, $50,000 is a lot of money. $50,000 in property itself is a lot. But after a 30-year career with the roots he has, it's informative to the court that there's not a single person out there that's willing, apparently, or able to stand that up. And that's a little bit eye-opening to the court. We're not talking about a 22-year-old kid who doesn't know people of substance or wealth, or haven't had time to accumulate something of value over the years. We're talking about a man in his 50s that, giving him the benefit of his service to the community and law enforcement. It's surprising. I really thought 50,000 bondable and $7,500 would I suspect the cash component would be imminently doable. Apparently, though, Mr. Pitaro, you take a different approach. And then finally, usually if I'm going to reconsider an order, I want there to have been a material change. The law changed, the facts changed, the court misapprehended or miscomprehended. And you saw the amount of time it took my staff and I to write that order. I mean, we didn't shoot from the hip on this. We took our time, looked at the factors. As I mentioned, I tried to give the benefit of the doubt to Mr. Handte. I know that jail's not doing him any good up there. I realize he's it's not a great situation. I get that. On the other hand, I'm going to have Mr. Stagey remind the court how we got to this point. The bail's already been considered twice. And so give me something from which you would ask the court to change its view.
Eloquently put, Gia.
Hey, let me ask you one question before I hear from Mr. Stagey. If I were to ask him right now, where will you live, Mr. Handte, when you make bail? What's he going to tell me, Mr. Pitaro? Because, on pretrial supervision, they want to make sure they know where he's living and it's an approved location, right? So where's he going to go the day he walks out on bail?
I know where there's free lodging.
I don't think he's going to walk out into the
How did Deborah get in there?
quite truthfully. It's not
That's
that he walks out
outrageous.
and then picks it. I think it has to be there first. And I believe he can tell you the address.
Well, do you mind if I address your client directly?
Absolutely not. I encourage it.
Oh, here we go.
All right, Mr. Handte. So if you make bail, where will you go live and with who? And do they know you're coming?
Well, Your Honor, I have family here that's predates me before I arrived in Reno, Nevada in 1974. They've offered to allow me to basically crash on the couch until I'm able to put some money together
Yes,
to
Ellen,
get an
that's in a
apartment.
nutshell.
Judge, I'm not going anywhere. I've been in the state for 47 years, 45 plus of that in Reno. I've got family and friends. I got a friend that said I could stay at his place for this period of time until I'm able to get on my feet. If you're going to ask me when I walk out the door of this Washington County Jail facility, do I have a place to go? I do.
Understand that he put himself there. Mr. Handte put himself there, and the court's own or anyone's own sort of subjective feeling bad for him is, again, cold comfort against the law. The law.
Okay, so that right there, I just gave him the summary. That's Steggy. Again, they both went on for 20 minutes. I give Pitaro a few seconds himself, but you get the gist.
It's process. The law is analysis.
And the concept of income is the one clear thing that we've attempted to get around.
All right, thank you. The matter submitted. I'll have a written decision out by Thursday at this time. 2 days.
Okay.
I'll go back and take another look at this. I mean, Mr. Pitaro, you're a very fine attorney if you're able to get this motion on, get it heard, and in the course of a week, right? I mean, Mr. Stegey, to his credit, he didn't say, Judge, I want 10 plus 3 plus 7 days to respond in writing, and then I said a hearing in 2 months. You want to know?
Don't worry.
You want to know? I'll take another look at this.
Alex,
see if I
knows
overlooked
about
it.
the
See
order.
if the fact that somebody apparently
Right here.
is willing to let Mr. Handte live there. If he bails out, I'll take another look at this. If it goes your way, it's with a reminder that he gets the GPS tracking before he leaves the jail, that he stays in Washoe County, that he does not associate with Mr. Hillygus while Mr. Hillygus is on pending warrant status. He continues to abide by the prior orders of the court, and that he stays on pretrial service supervision, including them knowing where he lives. On the other hand, if the court declines to revisit its order, it's not because I haven't heard you. It's because the court believes its reasoning was sound and does not find a reason to change it. That doesn't mean I'm not sympathetic to Mr. Handte or that he's not experiencing pain and discomfort in his back and other things going on in his life. It just means under the circumstances, taking into account everything that's transpired, the court would feel that its priority was fair and reasonable, is not inclined to change it. All right, gentlemen, thank you. Mr. Handte, thank you for your courtesy, being respectful of the court during this hearing. With that, Mr. Stege, Mr. Bitar, Mr. Handte, the court will be in recess.
Okay, so I wasn't going to leave you hanging. I did this video and I looked at it and we get to the end. Okay, so we find out the trial's delayed. It looks like July, right, Alex?
Right. That's
Okay,
correct.
so we're thinking about a July. I mean, and it's not happening May 2nd. That judge is going to see the Supreme Court justice give his keynote speech at that conference, come hell or high water. That's what's going on, okay? I don't know why he didn't just say it or not even mention it. Just say May 2nd doesn't work for the court. Next. But that's it. So we go through all this, and I found it fascinating, the discussion of severing the case. Again, you guys, anyone here is strong in the law nerd department. We're talking about severing the cases and jumping bail and bond hearings and intricate stuff. But I found it and also the competency hearing. But we get to the end of all this, and I wanted to do this to catch up. And then the judge says, I'm going to issue an order in 2 days. Well, I don't have the order.
Yeah.
But I did say to myself, my little law talk brain, I said, I know who might. And that's Mr. Alex. So what do we know about the order, Alex?
So I'm going to have a copy of the order on Monday, but I can see the title of the order entered March 30th, 2022, and it reads Order Denying Defendant's Motion for Reasonable Bail. So even though we don't know the reasons as to why it was denied, it's been denied.
Okay, so he's going to give his justification, but the judge denied it. And as he was talking, I thought this was a 2-inch putt. You deny this all day long. I think the judge was too reasonable in the bail that he set. I mean, I'm not yelling about it, but I'm just saying, like, if you're on the continuum, I thought he was on the over-generous side of the continuum to start with. By the way, before this sounds like some vast criticism, that's basically what the judge said. Sitting on the bench during this hearing, I thought he was overly generous, and Stege was not happy with it, and I don't blame him. It cracked me up when he said, "Oh, I need to find my response." There's no response. This guy can't be trusted. We've had 2 prior hearings, and there's no change of condition. I can do that. I don't need anything. It's not my case, and I can argue what Stege argued. But that's okay. He did a nice job. Too long-winded, as was Pitaro, but that's sort of what was going on. So he denies that. I'm guessing that means that Handte's still in jail.
Yeah.
We've got Hillygus out running around God knows where. If he's out, the problem is this. If he gets outside of Nevada, now you've got another jurisdiction and you've got to extradite him and all this nonsense.
Right. And that's probably what the concern is with the release of Handte, is if he runs again, I mean, it makes the government look terrible to be putting all those resources into reapprehension and all of these additional hearings and all that. I mean, I see why the court's concerned about that.
Okay, I did see another little video. By the way, the complete playlist on our Nevada judges who brings us all of this, or I would never see it. But I did see a short video, but I think that was regarding Stege's motion to not be seen. Was that recent? Or am I just looking at something old?
What do you mean not be seen? He doesn't want to be...
He brought some motion so that his face wasn't in the video or something like that.
Yeah, that's old. I mean, he's abandoned that. I think he was just using that as an excuse to try and get rid of us. That's way early on.
Okay. So I just came across that. But all right. So as we stand, it looks like a July trial date. Which, by the way, just as an attorney, I'm telling you, that doesn't mean it goes in July either. I mean, it could, but we're talking about a July trial date on a case where the main defendant is still at large and needs a psych eval before we start. The odds of that getting continued are high. I don't know if we've got speedy trial ramifications and those sorts of things, and I don't even do criminal law, and I don't practice law in Nevada.
Yeah, if I remember correctly, they both waived a speedy trial, and we got that on camera. I think that was way back when Joey Gilbert was one of the attorneys. And that was, we either have the Javs video up or we recorded that with the camera with the waiver. It's pretty common here for them to waive speedy trial.
Yeah. I'm torn on this too. I mean, the motion to sever makes no sense from a practical standpoint. I think they're better off. This sounds crazy. I think literally everybody's better off trying them together. Literally, both the prosecution and the defense. That sounds contradictory, but it's not. But if they did sever it, then we would just have 2 trials of it, which would be like crazy because you'll get different versions. Trust me. I've seen retrials of cases. You'll get different testimony. In what I do, a lot of times we'll consolidate for the purpose of discovery and then split because we have damages at civil. It doesn't matter, but you will get different responses at retrials or severed trials, and this is going to start crazy. So I mean, 2 variations of crazy. But I don't think that'll happen. I think we'll get 1. I don't think it'll happen in July.
I think it's going to depend heavily on whether Roger's apprehended. I think if he isn't apprehended, you're probably right. We'll probably see a continuance. But if he is, I think they're going to push hard for it to occur.
Well, and then the other thing is this raises another big issue. Would they just try him in absentia with a co-defendant? That's wild.
I don't think they can do that. I think that.
Oh yeah.
I wonder. What is there? I've always wondered about that.
Maybe not.
Wait, I don't know.
Maybe there's a reason you can't. Criminal defense attorneys in here, tell me.
Oh,
he's not. He's supposed to be in court.
Yeah.
You just set the trial and say that's it. We're going to find you guilty, and then when we find you, we're just going to put you in.
Yeah. For civil, it's very different. You're right. They'll just keep on going. If you just disappear in a civil case, they will keep on trucking without you. But criminal. I think that if the trial starts and then the defendant disappears, then they'll continue.
Civil's real simple.
Yeah.
Civil litigant. I represent plaintiffs. So if my client doesn't show up to trial, we lose.
Yeah.
We lose by default.
Yeah.
Okay. If the defendant doesn't show up, what we get is what's called dismissal. If the defendant doesn't show up, they lose by default, and then we set it for prove up because we always have damage issues which are separate from who's at fault.
Right.
But I wonder if they could just.
You need Debbie Davis, or
I don't know. Yeah, I need some criminal people. Just tell me in the comments. Tell me in the comments. But thank you very much, Alex. I appreciate it. Go over to our Nevada judges. They've got this. Are there other hot things we need to know about? Are there other fun cases coming up?
Fun cases. Probably, I would take a look at Todd Matthew Phillips versus Mark DiCiero, and. Oh yeah, there's another one with Kurt Harris versus Ernest Del Casal. Those are 2 that are interesting.
What about the guy's brother?
John McDonald, also interesting, but I think that one's sometime in June or July. That one is not around the corner. So,
okay.
Yeah. And that one might keep continuing. I mean, when I look at that case, I'm like, this is one that could just keep on continuing until there's a deal. I don't get the sense of urgency in that one that I do in some of the other ones.
All right. Well, thank you all for coming out. I appreciate it. Thank you, Alex.
You're welcome.
Have a great Saturday, everybody.
Bye, guys.